Well, this is week 8, and the lecture today that y'all will talk about here is legal protections against wrongful termination. And this is a good chapter because it's a big summary chapter of what we've been talking about and what you've been studying in this class. Again, this is a supplement to the reading and the other assignments and does not replace those. So let's get started with this lecture, and it should be a good summary for you guys of what we've been talking about. And so as we go into this, if you'll recall, the basis of employment law is at-will employment. And we're going to go back, and here's the definition again. It's an employee or employer may end the employment relationship at any time, with or without cause, with or without notice, for a good reason, bad reason, or no reason, except as required by law. And what we've been talking about this class is the exceptions so far. And all the things when you cannot just simply rely on that will employment. And when an employer wants to terminate an employee, they have to ask certain questions to determine what are the exceptions with respect to that employee. Because if you don't, you may end up with a situation in which you have an exception that's applied, but you did not recognize that and terminated the employee and created liability on the company at the end of the employment relationship that you were not anticipating. And so to do that, you have to ask certain questions. And what are the exceptions? And what are the sources of those exceptions? And we know the Constitution. There's the Constitution of the United States, and each state has their own constitution. Now, we haven't gotten into the state law constitutions here. They typically don't provide a whole lot in this context, but what we're talking about here is the U.S. Constitution, and when it would apply and when it would not. Statutory exceptions, and that's federal and state statutes, and those can provide definitely different exceptions depending on what those laws provide. And a lot of times the states provide more protection than the federal government statutes. And then common law. And that's really contractual law, contract law that is developed. And what does a contract provide or not provide with respect to the employment relationship? And then certain torts can provide additional protections on behalf of the employee with which the employer needs to pay attention before they terminate and end an employment relationship. So one of the exceptions that we were talking about just on the previous slide is the Constitution and the constitutional exceptions by the federal Constitution and the U.S. Constitution and state constitutions. And these will apply to public employees. And again, that's not companies that are traded on the stock exchange, but public employees, meaning governmental employees or employees employed by municipalities, states, or other governmental entities. And because they are employed by those entities, they are entitled to, under the state or the federal constitution, certain free speech rights, as well as rights under the 5th and 14th Amendment for equal protection. And there's also some privacy rights they're entitled to that are provided by the Constitution. Those employees also have a property right in their positions and typically can only be terminated for just cause and after due process has been provided to them. As with the preceding slide, the question you ask yourself as to the constitutional slide is the person employed by a private or public employer, to determine if that applies, and do you have to watch out for those exceptions before you make a termination decision. Here on this slide, statutory, you're going to need to find out which of these laws apply or don't apply. And so your questions really are as to this second bullet point here, which protected classes is the employee involved in? And so do they have a disability? Will the ADA apply? Is the person over 40? Does the ADEA apply? Is the person, if it is a woman, or what's their race, and which of the Title VII protected classes would apply? Have they taken any types of leave under the leave statutes, like the Family Medical Leave Act? Do they have any rights because they're a union employee or under the National Labor Relations Act? The other statutes, anti-retaliation statutes, there's some under OSHA, there's some under the ERISA. If they are trying to exercise a right under one of their plans, a medical plan, you can't terminate them for that. That would be a retaliation statute. It also falls under any of the Title VII ADA and ADEA statutes. Have they engaged in protected activity under those statutes, which would be the retaliation requirement that they've engaged in protected activity and now can't be retaliated against. Whistleblower protection laws. Have they complained of illegal activity and not performed the illegal activity, that they would have some kind of protection? Have they taken some kind of protected leave? Have they served on a jury duty, and that's protected leave, or served in the military and now come back, and are they protected under that statute, USERRA? Or is there some kind of state statutory law or protected class that would apply to them, such as, under those, some obesity, are they obese? That's protected under certain laws, or marital status is protected under certain state laws, or smoking is protected under certain state laws, or tobacco use, which is usually like the bluegrass states where they do a lot of the tobacco production. Those could be protected class status situations under those laws. So what you're really doing is trying to figure out which laws would apply to them. So you need to know what state, so you know what state to look at for protected classes. What are the protected classes the individual has? And then what types of leaves they may have taken, to see if those statutes are applicable and would prevent what we're looking for, an exception to at-will employment. Are we terminating them for some protected right that we're not allowed to under at-will employment, because it would be an exception to it? Also, under Montana, has a state law, and those employees in Montana is the one state where at-will employment is not the default rule. And so if they're in Montana, you would need to ensure that you're not violating their state law with respect to taking people outside of at-will employment. With respect to the common law, there's two really areas of common law that can be created that can create exceptions to at-will employment, and that's contractual and tort. And first we'll talk about the contractual exceptions. And so where do you look? You ask, does the employee have some kind of express written employment contract with the company? If so, you need to look at that before you can determine whether you can terminate them and what will be the consequences if you do terminate them, as spelled out in the employment contract. If they're union employees, they will be a part of a collective bargaining agreement. And so if they're union employees, they will also fall outside of at-will employment, and there'll be an exception there. Do they have some kind of implied contract theory that people have been telling them over and over, that we will not terminate you if certain circumstances don't take place? And that can, if it's specific, can become an implied contract or a verbal contract. Certain states have a covenant of good faith and fair dealing. It says you can only terminate under good faith and fair dealing under certain contracts. And certain contracts in states imply, once you enter into a contract, a covenant of good faith and fair dealing. And then also as part of a promissory estoppel, have you made some promise to them that hasn't yet come to the level of a contract, but a promise upon which they relied, and that they then have some type of contractual remedy because they relied on the promise. And I'll give you an example. If you told an employee to move to the state of Texas to have a job, and we'll have a job here waiting for you, and then they sold their house, paid moving expenses to come here, so they relied on that promise to their detriment. They came here, and then you say, hey, your job's no longer available, at will employment. There's a good chance a court would say, look, you have that right, but you promised them, they relied on the promise that there would be a job, and so you're at least have to pay them the damages they incurred on relying on your promise by moving and paying the expenses to move to Texas. And so these all are exceptions to at-will employment, and that we've talked about throughout this class is in the book throughout this year, and are exceptions to the at-will employment that fall under the common law contractual concept. And then finally, there are certain common law tort claims that have been talked about in this class that are public exceptions to that will employment doctrine. And those come up with mainly the bottom parts here: defamation and privacy torts. That if you make false statements about them or violate their privacy by doing searches that they had an expectation of privacy, then if you terminated them for those reasons, for instance, if you told them we will not search your purses or we will not search your lockers, and then you did search their lockers, they would have had an expectation of privacy there. You violated that. And they, if you terminated them for whatever you found in their purse or locker, if you did not set the expectation of privacy properly and waive that for them by saying, look, you have no expectation of privacy in those locations. If you didn't do that, then you could be subject to a privacy tort, and that would provide an exception at will employment. And defamation, like if you defame them, that's another claim that even though they're at-will employee, they could sue you for doing that. And where's defamation? Let's say someone violated a drug testing policy, or you believe that they committed some kind of theft. You could fire them for that, fine. But then if you start making comments that they're a drug addict or a thief, those types of statements can definitely lead to defamation claims. And if you can't prove absolutely that they did steal or that they're a drug addict, then they would have a claim, and that would be an exception to at-will employment created there. False imprisonment doesn't come up often. It was in the book, so I listed it here. And then other public exceptions, policy exceptions that fall under, and some of those, I'll give you an example or two, is in the state of Missouri, they have a public policy exception that if you're an organ donor and you go to donate an organ, then you cannot be terminated for participating in the organ donor program of that state. And so those would be other kind of public policy exceptions that could come into play. And so why I believe these are good questions to ask when you're terminating someone is because you're trying to judge the liability when you're ending the employment relationship, and what possible situations could come up as the exceptions of to at-will employment. And so what I do when questioned about can you terminate someone or not, I go through these list of questions here as kind of set forth in these slides. Again, are they a public or private employer? Meaning, does the Constitution apply or not? What state are they in? What city are they in? So I can understand what laws would apply, so I can determine what protected class statuses I need to be on the lookout for. What leaves have they taken? Those kind of questions will answer those to see what statutes would apply. And then under the common law, are they do they have a contract through that you've entered into them with or not? Or are they a union employee that would have a contract? And how does that affect that will employment relationship? And then finally, the violation of any torts that would affect it. And now we've gotten through the employment process. The person's been separated. What would then come up, as we talked about it earlier in the contract week, where we talked about employment contracts, could be the now enforcement of a non-compete or other type of restrictive covenant, because now they're no longer an employee and they're somebody else's employee. And can you go enforce those restrictive covenants if you were able to enter into one with the employee through an employment contract? And then they'll be going on and being hired and going through the hiring process, which we already talked about throughout this course and was in the book, and they'll start interviewing and going through that process with someone else. So it's like the secular nature of the employment relationship. And we're at the end of that with this slide presentation. And thank you. It's been fun talking to you through these weekly presentations as a part and as a supplement to your online studies. Thank you.